Ladies and gentlemen, it is on. You got Harrington here. Hey, check out the new digs. What do you think? Space Connect redid his podcast room. Pretty sweet, huh? But let's finish this up. So, recall. First part of the series, we talked about the pleading stage. That's getting the case off the ground. Then last week, we talked about the judgment stage, which is the showtime. All right, so now the show is over. Do we get to all pack it up and go home? Well, here's a depressing thought if you're thinking about this from the point of view of how much the whole ordeal is going to cost you. In some cases, you may actually just be getting started. I'll explain what I mean. Here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. We need to talk about outcomes because to say that there's a winner or a loser, that's imprecise. In fact, it's usually something in between, right? So if we say you're the winner, it just means that you probably got most of what you were hoping for. I feel like there's a bit of a tendency, like in human nature, both among juries and among judges, that they like to kind of divide the baby a little bit. And maybe that's the reason why most of these cases probably should settle because, well, you know what they say about a great settlement, everybody's unhappy. Well, let's just go with that definition. When I say winner, I mean that, maybe you won on paper and or you got a lot of what you were hoping to get. Now let's talk about the losers because that's actually more nuanced. So obviously you didn't get all that you were hoping to get. That's obvious. But let's break this down a little bit. What if it is the case that you got everything you could reasonably have hoped for? Now, I understand in your mind, you're going to the grave thinking that you were 100% right. I'm not expecting you to confess that may not necessarily be the case. I'm just saying that if in reality things could have been much worse, is that really a loss? Or here's another one. Let me put it to you this way. Let's say that, prior to the trial, you guys went to mediation because we have to go to mediation. You beat each other up to get to the best settlement numbers possible. And at the end of the whole ordeal, there was a number on the table or an offer on the table, and you rejected that offer. And then you went on to trial and you did better at trial. You still technically lost the trial, but you did better than what you would have if you had taken that settlement offer. Did you then lose? So you see what I mean, guys? These things aren't so black and white. There's nuance. Part 2, losers. I just undid the whole explanation I gave. Right? You and your attorney are going to pore over everything that happened at that trial. You're going to read every word in the transcripts. You're going to look at the procedural decisions that the judge made along the way, and you're going to look for defects. And now I'm about to get a little bit obnoxious, so stay with me here. I love you people. Don't take this the wrong way, but juries, you don't know what the hell you're doing. Your minds wander, you miss important evidence, you don't want to be there, you end up going with the attorney whose hair you like better. I mean, honestly, I don't know how you guys make your decisions. And look, I'm not complaining because a lot of times the system plays in my favor. So, I'm not complaining. But let's be honest, it is an imperfect system. And I don't want to let judges off the hook either. They also get tired. They also misunderstand case law. They also make mistakes. I mean, they're trying so hard to keep things moving. They're also human. So if you were the loser in the case, then you're going to need to look at all these things and make a decision with your attorney as to whether or not an appeal makes sense. Of course, in some cases, you may want to appeal even if it doesn't make sense. I mean, you're not going to lose any worse, right? You're going to be out the attorney's fees, but, what the hell? And speaking of attorney's fees, that's really what we're here to talk about, right? Okay, I'm not an appellate attorney. I'm probably not the best one to give you this number. I know they're expensive because, well, even over drinks, I can't really get it out of them. So you know what I mean? Ouch. But I owe you a number, and I do handle appeals when it's in an area that I know very well. So here it is, 10 to 20. I'm going with $10,000 to $20,000 for your appeal. Now, what is involved in an appeal? Not a whole lot, actually. I mean, if you're the appellant, you're the one bringing the appeal, then you're going to pay for your attorney to file an initial brief. The other side then is going to file an answer brief. And then you have the opportunity to file what's called a reply brief. You don't have to, but if they're giving you a chance to get the last word in, you should take it. So you're thinking, well, 10 to 20,000 for 2 briefs, those must be some amazing briefs. Well, they actually are. A lot of work goes into these things. They're going to be highly technical. It's a lot of research. There's going to be a whole index, references to the transcript. A lot goes into it. Part 3, you winners. Believe it or not, you actually have more to consider. I mean, first of all, just segueing off the last section, you may be defending an appeal, right? And if there is going to be an appeal, then you have a decision to make about settlement. I know, your settlement, well, I already won the trial. What am I settling for? Well, you've heard about these big cases where, there's billions, millions of dollars, whatever, a lot of money on the line. But the winning party doesn't end up actually getting all that money, because if they had enforced that judgment or tried to enforce the judgment, then the losing party would have simply filed bankruptcy and the winner would have to get in line with all the other creditors. So if you're faced with an appeal, especially one that might have a little merit to it, then you are once again going to need to think about the possibility of settling with the other side. Even though you've already won the trial, you may still want to settle. I'm going to try and give you a number. It's very hard. It just depends upon how complicated the trial was, how much you have to look over, what the discussions are with the other side. It's very hard to say, but I promised you a number, so $2,000 to $5,000. Now this is the part I really wanted to get to. You as the winner have yourself a little piece of paper that says you're the winner, but that piece of paper won't cash. You can't take it to the bank. You are still going to have to execute on that judgment. Now, I should say, in some cases, the losing party may just stroke out a check and everybody's happy. That's the end of the story. But very often, unfortunately, you may find yourself having to chase the money. How are you then going to turn that piece of paper called a judgment into actual money in your bank account? Well, you're going to garnish bank accounts. You're going to garnish wages. You're going to lien investment properties. Homesteads are off limits, unfortunately, but investment properties are not. You're going to lien other things like boats and vehicles. But that process can take time and money. And sadly, you are going to have to pay your attorney out of your own pocket for him or her to do all these things to get you paid. So I got to give you a number, $10,000 to $12,000, depending upon how much of this you have to do. Maybe less, but if you have to do all those things we just talked about, probably $10,000 to $12,000. Let me hasten to add this though, at least now there's no uncertainty. At least you are in a position of strength, and you're going to recover, assuming that these efforts are successful and there's actually some assets that you can liquidate. You're going to get to some cash. You are going to recover every dime that you spent paying your attorney to do those things, and the cost as well. And as I said, most importantly, there's no uncertainty. There's no possibility that you could go to trial and lose. Now you're in a winning posture. One other thing we need to talk about. Let's say that the losing party has some jackass like me who knows a lot about asset protection, and he's setting up things and moving things and all that's happened. Well, if there's any chance of that going down, or it's already gone down, then you have to do depositions. You have to do depositions because you got to put this person under the spotlight, under oath, and don't give this person time to move things offshore, set up trusts. Don't let them talk to their attorney. They can't have the time to think up their story, right? Or what they want to tell you, what they don't want to tell you. You gotta have, the attorney doing the deposition has to him or herself be an asset protection expert to know the right questions to ask. But you really have to set up that dynamic. That's the only way you're going to be able to cut through whatever scheme they've put together. Now, again, back to money. Harken back to the first part of our series here. Depositions are expensive, unfortunately. $3,000 to $5,000 per deposition. Just one quick thing, in all frankness, there are some firms out there that focus just on executing on these judgments, and some of them may do that on contingency. I mean, they know that they're gonna, if they find assets, they're gonna recover all their attorney's fees as a matter of law. And then they may do all that work on their own dime in exchange for some percentage of the recovery. We don't do that, and these firms are very selective about the cases that they take, so that may not be an option for you, but I wanted to let you know. And that is it, guys. I hope this series on litigation didn't make you feel too much like you were eating your vegetables. I hope you found this useful. In any event, now when you ask me, how much is this lawsuit going to cost me? I've given you the very best answer anybody could. Y como siempre, recuerda que hablamos español. And I promise next time we'll be a little more uplifting with the topic. So until then, guys.